I believe we do have an email question that just popped up on the screen, so we'll just kind of jump right into that. I'm joined by my law partner, Les McFadder, so he's with us tonight as well. But let's just get to this question. So my mom was killed in a wreck while on the job. It was the other driver's fault for crossing the center line, causing a head-on crash. Her husband says that to bring a wrongful death lawsuit, my sister and I have to name an administrator as there is no will. Is this true? We don't really trust him and are afraid he'll keep any settlement for himself. Can we file our own wrongful death lawsuit, Crystal? So, as stated earlier, we've got attorney Les McFadder. He's one of my law partners at Perry & Young. Les, you want to take a stab at that, buddy?
Yeah, absolutely. First off, Crystal, I'm very sorry to hear about that. It's always devastating when somebody loses a loved one as a result of an accident, especially because it was so unexpected. But in order to file a lawsuit, there actually is a process. They're somewhat correct in talking about an administrator. In Florida, we call it a personal representative. There's actually a wrongful death statute. It's a set of laws that are codified in statute that deal with wrongful death claims. And in the state of Florida, in order to bring a wrongful death claim, it has to be brought by the personal representative of the estate. The personal representative is somebody that is appointed by the court to bring the claim on behalf of the estate and also on behalf of all survivors. The wrongful death statute also names specifically who survivors are, who can recover, and it's typically spouses. If there is no spouse, it could be children. If there's no children, it can be parents. It just depends on a variety of circumstances, and there's some limitations that go along with that. Now, to get to your question about her husband and not really being trustworthy, in Florida, spouses have what they call their priority. They're more of a preferred personal representative, but a personal representative can be anybody. It can be a family member. It can be anybody over the age of 18 as long as they don't have a felony. And so usually if there's a situation where there might be some trust issues, the best thing to do is to maybe try to come to some sort of an agreement. You can actually have a professional personal representative hired. Sometimes we have lawyers here locally if there's some issues with a family and we need somebody that's more independent and neutral. You can get a professional personal representative to be appointed to bring those claims. But yes, that is the process. You have to have a personal representative named, and that's regardless of whether there's a will or not. You have to have a personal representative. The will typically will name an administrator, and that person would typically also be the personal representative, but it doesn't have to be.
So Les, in this situation, there's a couple things that jump out. First off, they didn't have a will.
Right.
So that's the importance of having a will, because you explained to the court exactly what you want to happen in your case. I mean, or at your death, I should say.
Right.
So, somebody could ask, say, well, who gets mama's china? But you can also say who's administrator of your estate as well. Right. You can tell the court basically what you want to have happen. So it's very important, if you don't have a will, find an attorney, find a law office that can draft you up a will. And please, by all means, don't try to do it yourself, because a lot of times people try to go to the box stores, get the will out of the box, they fill out the form, hey, I've got a will. And guess what? It's done inaccurately.
That's right, right. And sometimes that might be better than nothing. But the Florida law actually has a procedure in place. If you die without a will, you're considered to have died intestate. And so if you die intestate, that means you don't have any say over how your assets get distributed. Those assets are distributed based on what the statute says when you die without a will. If you're married, typically everything goes to the spouse. If you or at least 50% if you are married and have kids. If you aren't married and you die, then everything goes to the kids. It's divided equally. And so what the personal representative would do in that situation is they're required to take inventory of everything the person owns, basically cobble everything together, bank accounts, investments, real estate. They want to monetize everything, and then they distribute that money, the proceeds from the sales of those things, based on the intestate succession statute or based on whatever the will sets forth. It is best to have a will. I mean, especially if you want to have some control over who gets what. Maybe you've got somebody that has a special need. Maybe you have somebody that you want to help out in certain ways. Maybe you've got a situation where you've got younger children and you don't want them to have, even though they may be 18 or 19, you may not want that 18 or 19-year-old to have all that money at one time. So a will is always going to be the best thing because it allows you to plan.
Right.